and myself a very warm welcome to our chief guest, Judge of the Honorable Supreme Court of India, Honorable Mr. Justice K.V. Vishwanathan. Sir, it's our absolute pleasure and honor to have you with us today to inaugurate the 4th Summer School on Mediation. Our very warm welcome to our guests of honor, Dr. Peter Maynard, President of the Commonwealth Lawyers Association, and Mr. George Lim, Chairperson of the Singapore International Mediation Center. A special and heartfelt welcome to the students and all the peacemakers and enthusiasts of mediation who have joined us today from different time zones, starting from 5:30 a.m., I think, for Mr. Peter Maynard. I'm Shireen Khajuria, a mediator and an advocate of the Supreme Court of India, and it's my privilege to be your host today. This 4th edition of the Summer School of Nivaran is unique. That is because we are doing this in collaboration with the very prestigious Singapore International Mediation Center and the Commonwealth Lawyers Association. Thank you. Nivaran, a term in the Hindi language, which literally means to redress or to redress a grievance, is a body of mediators of the Supreme Court of India. It was organized with the aim of promoting mediation and for continuous skill enhancement of mediators. It had its first program, physical, in January 2020 at the Indian Law Institute when we invited a seasoned mediator and barrister from London, Mr. Andrew Miller, to be the chief guest in the presence of judges of the Supreme Court. But thereafter, COVID-19 hit us. Nivaran, however, quickly adopted to the new normal, and with the support of technological advancements, we have been hosting mediation programs virtually since. So far, we have hosted 4 seminars, nearly 25 guest lectures, and this is the 4th year in a succession that we are hosting the Summer School on Mediation. This is a 12-day program, inclusive of today's inaugural ceremony, and the closing ceremony is to be held on the 2nd of August. We have guest speakers from across the nation and many parts of the world who are well-established experts and teachers in mediation. They will speak on topics ranging from the genesis of mediation and dispute resolution, mediation advocacy, ethical issues, and on the Singapore Convention. I may mention that all the attendees will be given certificates of participation at the end of the series. To begin with, Mr. Rakesh Khanna will give the welcome address. Mr. Khanna is a former Additional Solicitor General and a designated senior advocate of the Supreme Court of India. Mr. Khanna has also been president of the Supreme Court Bar Association. He's a member of the Supreme Court Mediation and Conciliation Committee and was also a member of the Supreme Court Legal Aid Committee. He is one of the founder members of Nivaran. Mr. Rakesh Khanna, may I please request you to give your address?
Thank you, Shireen. Honorable Mr. Justice K.V. Vishwanathan, Judge, Supreme Court of India. Mr. George Lim, Chairman, Singapore International Mediation Center. Mr. Peter D. Maynard, President, Commonwealth Lawyers Association. Shireen Khajuria, host for today's program. Mr. S.S. Ray, our co-host for today. Mr. Santana Krishnan, Mr. Ben Spear, former president of the Commonwealth Lawyers Association, Mr. Rajiv Datta, Mr. J.M. Sharma, my colleagues at Nivaran, my colleagues and friends from the bar, and my dear students. Nivaran, mediators of the Supreme Court of India, Singapore International Mediation Center, and Commonwealth Lawyers Association extends a warm welcome to our chief guest, Honorable Mr. Justice K.V. Vishwanathan, and our guest of honor, Mr. George Lim and Dr. Peter Maynard, as well as all my respected colleagues, dignitaries, participants, faculty, and friends to the inaugural ceremony of 4th International Virtual Mediation Summer School 2023. Nivaran, Mediators of Supreme Court of India, started its journey in January 2020 and till date has organized 25 international webinar addressed by various renowned experts, legal luminaries, and titans of mediation from various jurisdictions in the world. Nivaran organized its first international mediation summer school in the year 2020, and this is our fourth such endeavor. This year, Nivaran is fortunate enough to get support from esteemed Singapore International Mediation Center and illustrious Commonwealth Lawyers Association. Mediate, don't litigate is the latest message from the Honorable Chief Justice of India, Dr. D.Y. Chandrachud, advising the government to switch from adversarial litigation to alternate dispute resolution route, particularly mediation, in order to declog the courts and promote an alternative, collaborative, interest-based conception of justice. Accepting the advice of Honorable the Chief Justice of India, Government of India has issued an office order dated 29th of June 2023, requiring all its departments, undertakings, and companies to adopt the route of mediation to resolve their disputes with private contractors, including those where the arbitration awards have been passed and matters are pending before the court. India is on the verge of getting its self-contained mediation legislation. Once the Parliament passes the legislation on mediation, a large number of well-trained mediators would be required to handle the disputes pending in the court and or arising in future, be it family feuds, commercial cases, service disputes, or disputes of other natures. In the light of both of these developments, this International Mediation Summer School assumes a great significance, and it will be in the aid a large number of advocates, students of law, and experts from various other fields and proficiencies to take up the task of mediating disputes in times to come. Mediation, as we all know, is a voluntary, party-centered, structured negotiation process where a neutral third party, that is the mediator, assists the feuding parties in amicably resolving their disputes by using specialized communication and negotiation skills, public techniques to help them realize what they want and why, what they will give to get it, what they think the other side wants and why, what they think the other side will give and get it, and the risk of themselves and other side of not reaching settlement, which greatly increases the chances of successful settlement and permanent resolution of the entire dispute. If I put the process of mediation over the litigation, I'll summarize them. Firstly, it is voluntary process where the parties retain to themselves the right to decide whether to settle the dispute and on what terms. In mediation, the right of self-determination is central element of any mediation process. Thirdly, the parties have ultimate control over the outcome of mediation. They have the liberty to withdraw from the mediation proceedings at any stage without assigning any reasons. Mediation is a party-centered process, and the role of mediator is that of a guide who helps the parties to develop solution to their disputes. Mediator neither adjudicates nor decides the dispute between the party. With his or her communication skills, out-of-box thinking, and ability to facilitate negotiation, a mediator certainly facilitates and guides the parties to arrive at mutually acceptable solution. Mediation is an informal process not governed by any rules of evidence or procedure. It is speedy, convenient, and less expensive process which helps to permanently give quietus to the disputes with dignity, mutual respect, and civility. Any statements made or evidence adduced in mediation cannot be used in any adjudicatory proceedings in court nor can the mediator be called in evidence to testify about any statement made by any party before him or her during the mediation process, or as to what transpired in the proceedings before him or her. Mediation gives the parties the freedom to develop new, innovative, and creative solutions for their disputes that are specifically tailored to their needs and circumstances and peculiar to their exact case. In mediation, parties do not have to take the trouble of submitting their written pleadings, reading evidence, cross-examination, face trial, or the arguments. In the event of successful mediation, both the parties are in a win-win situation as their dispute is resolved to their mutual satisfaction. Resolution of disputes in mediation helps the parties in maintaining or rather improving their relations, especially in family, business, or commercial disputes, as also in the case of employer-employee relations disputes. If the mediation does not succeed, the parties still have a right to approach the court for adjudication of their disputes. In mediation, the parties have everything to gain and nothing to lose. Friends, it is my privilege to welcome Honorable Mr. Justice K.V. Vishwanathan, Judge, Supreme Court of India, who has recently been elevated directly from the bar. Justice Vishwanathan has been a renowned senior advocate with roaring practice and is widely considered to be a darling of our bar. We are grateful to His Lordship for graciously accepting our humble invitation to preside over the inaugural ceremony of the International Mediation Virtual Summer School 2023 as our venerable chief guest. I, on my behalf and on behalf of everyone present, extend a very warm welcome to your Lordship. Our first guest of honor today is Mr. George Lim, who is revered senior counsel and chairman of Singapore International Mediation Center. He is widely regarded as father figure of mediation movement in Singapore. Mr. Lim is pivotal in making the Singapore Convention on Mediation a reality. I extend a very warm welcome to you, Mr. George. Dr. Peter Maynard, our second guest of honor today, is designated King's Counsel in Bahamas, teacher at University of Bahamas, and president of Commonwealth Lawyers Association, which comprises of almost 80 Commonwealth countries across the world. I extend a very warm welcome to you, Peter. I also welcome all the participants of this year's International Virtual Mediation Summer School. During the course of next 10 days, you will learn about the various facets of mediation, acquire numerous skills, and be exposed to a wide variety of techniques from a faculty of acclaimed experts in mediation. I am positive that this iteration of International Mediation Summer School will again prove to be a highly enlightening, edifying, and enriching experience for everyone involved. Thank you very much.
Thank you, Mr. Rakesh Khanna, for your welcome address. I would now like to introduce our first guest of honor, Mr. Peter Maynard. He's the president of the Commonwealth Lawyers Association. He's also a teacher, prolific writer, and a senior attorney from the Bahamas, specializing in arbitration and asset tracing and recovery. Mr. Maynard completed his graduation from the McGill University and went on to do his MA and PhD distinction in international law from Johns Hopkins University and LLM from the University of Cambridge. He was admitted to the Bar of England, Wales, and the Bahamas in the 1979 and was admitted to practice in St. Lucia, Antigua, and Trinidad and Tobago in the year 1986. Mr. Maynard is also the head of the law department at the University of Bahamas and a lecturer and adjunct professor of international law and corporate governance. He encourages young students all over the world to engage in ADR, alternate dispute resolution. He has been, in fact, elected as chair of the Bahamas branch of the Chartered Institute of Arbitrators, which is a leading global institute of professionals and students that provides training in and promotes arbitration. He is multilingual and can speak English, French, Spanish, Italian, German, and Arabic, I believe, amongst other languages. Mr. Peter Maynard, can I please request you to take the floor?
Thank you so much for those words of welcome. May I take it that protocol has been established. Distinguished honorable judge and other judicial and personnel, my distinguished guests, distinguished ladies and gentlemen, good morning, good afternoon, good evening. It is my honor and privilege to make some remarks today on the evolving landscape of mediation as a transformative means of settling disputes, reducing court backlogs, and as a part of a holistic approach to dispute avoidance and management. Permit me to quote a number of persons. As we delve into the profound impact of mediation, I am reminded of the words of Mahatma Gandhi, who said, "An eye for an eye only ends up making the whole world blind." Mediation's essence lies in breaking this cycle, steering us towards a path of reconciliation and understanding. In recent years, we have witnessed a significant shift in how societies perceive and approach conflict resolution. While traditional litigation has been a staple in settling disputes for centuries, it is becoming increasingly apparent that alternative methods, such as mediation, hold great promise in delivering efficient and sustainable solutions. As Nelson Mandela once expressed, if you want to make peace with your enemy, you have to work with your enemy. Then he becomes your partner. Mediation embodies the spirit, transforming adversaries into partners, striving for shared resolution. Mediation at its core fosters a cooperative environment, enabling parties to engage in meaningful dialogue and work together to find common ground. By doing so, it paves the way for creative and mutually beneficial resolution, steering away from the win-lose mentality of court battles. This approach not only saves time and resources, but also helps to preserve and even strengthen relationships, which are often strained during court conflicts. A compelling reason for embracing mediation is its capacity to address the mounting issue of court backlogs. Overloaded judicial systems have plagued our legal institutions for years, resulting in delayed justice for countless individuals and businesses. However, as mediation gains momentum, we witness its potential to alleviate this burden by diverting certain cases away from the courtroom and towards a more efficient and expeditious resolution process. Moreover, the words of Martin Luther King Jr. resonate deeply in this context. Peace is not merely a distant goal that we seek, but a means by which we arrive at that goal. Mediation serves as a powerful means to achieve lasting peace by empowering individuals to actively participate in crafting their own solutions. Nevertheless, mediation is more than just a quick fix for overwhelmed courts. It is an integral part of a holistic approach to dispute avoidance and management. As American author Maya Angelou once wrote, "Do the best you can until you know better. Then when you know better, do better." Mediation equips individuals with the skills to manage conflicts more effectively, encouraging them to strive to continuous growth in resolving disputes amicably. The changing landscape of mediation is being driven by a confluence of factors. First and foremost, there's a growing recognition of its efficacy in various domains, including commercial, family, workplace, and community disputes, as has been said. This recognition has led to the integration of mediation into the legal system, with many jurisdictions now mandating and encouraging its use before resorting to litigation. Secondly, advances in technology have expanded the reach and accessibility of mediation services. Virtual platforms have broken down geographical barriers, allowing parties from different corners of the world to engage in dialogue, as we're doing today, facilitated by skilled mediators. This digital leap not only has reduced costs, but has also enabled a wider spectrum of individuals and businesses to avail themselves of mediation's benefits. Furthermore, the shifting societal mindset towards dispute resolution emphasizes the value of collaboration and restorative justice. As we acknowledge the limitations of punitive measures, we must embrace the transformative potential of mediation to heal wounds, rebuild relationships, and foster a shared sense of justice. In today's interconnected and complex world, we are faced with multifaceted challenges that require adaptable and forward-thinking solutions. Mediation offers us precisely that, an adaptable and forward-thinking way to address disputes with sensitivity and innovation. It transcends cultural, social, and legal barriers, making it truly inclusive as a method to resolve conflicts. Over the past several months, I have joined the Commonwealth Lawyers Association's ADR committee in recommending to governments, and this initiative has been headed by Santan, my dear friend Santan, in recommending to governments across the Commonwealth that they sign on to the Singapore Convention on the automatic enforcement of settlement agreements. Of course, Mr. George Lim is also a leading figure in connection with the Singapore Convention. With your help, that convention can be as successful as the 1958 New York Convention on the automatic enforcement of arbitral awards. Let us acknowledge the transformative potential of mediation and the changing landscape it creates. We must recognize its power to bring people together, to mend relationships, and to forge a more harmonious society. Let us collaborate across disciplines and borders, embracing mediation as a vital instrument for peace, progress, and justice. I encourage you all to actively engage in the trainings ahead and sharing your experiences and insights. As British author J.K. Rowling aptly said, we are only as strong as we are united, as weak as we are divided. By working together, we can build a world where conflicts are approached with compassion and creativity, where disputes are not merely stumbling blocks, but stepping stones towards a more united and harmonious global community. I congratulate and thank Navaran for putting on this training, especially Santan and his team. Thank you for the financial contribution to the CLA, and also to extend every good wish to each and every participant, speaker, lecturer, and organizer of this event. Very much.
Thank you so much, Mr. Maynard, for your insightful address. Our next guest of honor is Mr. George Lim, and it's my pleasure to introduce him. Mr. George Lim is the chairperson of the Singapore International Mediation Center, commonly known as SIMC, since the year 2017. He started his practice as a lawyer in January 1982 and has received his mediation training from Center for Effective Dispute Resolution, the United Kingdom in 1996, and from the Harvard Law School in 2001. Mr. Lim was appointed as a senior counsel in 2010. He's a pioneer in mediation. He assisted in the establishment of the Singapore Mediation Center in 1997 and was elected as the first chairman of the Asian Mediation Association in 2009. In 2014, Mr. Lim was appointed as the deputy chair of the Singapore International Mediation Center. He was actively involved in the adoption of the Singapore Convention on Mediation in 2019. He was awarded in 2020 the Public Service Star by the President of Singapore for his contributions to mediation. In 2022, Mr. Lim was named by the International Who's Who of Commercial Mediation as a global thought leader in mediation. During his 40 years career, Mr. Lim has trained lawyers and judges in mediation from the Philippine Judicial Academy, the Malaysian Bar Council, the Thai Judiciary, the Fiji Judiciary, the Dubai International Financial Center, Myanmar's Judiciary, and I could go on and on. I hope to have the honor of being trained by you someday, sir. Aside from being a mediator, Mr. Lim is the founder of the Society's Criminal Legal Aid Scheme, which provides free legal representation to people accused of crimes who cannot afford lawyers. Mr. Lim has admitted in one of his interviews that he enjoys watching the Korean dramas with his wife. I believe he's choosy about it, what he was saying just now. He also enjoys traveling and spending weekends with his adorable granddaughter. I'd like to quote Mr. Lim's advice to young mediators: learn to mediate with the heart. Once the parties feel that you are sincerely trying your best to help them, you will get there. Mr. Lim's, over to you.
Thank you, Shireen. Namaste, everyone. Honorable Justice Vishwanathan, Dr. Peter Menard, my friend, who co-mediated a case with me very recently in Singapore, honorable judges, friends, and of course, Santan for inviting me to this session. Shireen, I've forgotten all that, really. And I must correct you, I have 2 granddaughters now.
Yeah. Thank you.
Yeah, and they are the joy of my life, really, today. When I'm not mediating, I babysit. Very therapeutic. Okay, I'm really proud to be part of this session. I have spoken here before, and I think I consider many of you friends. And we are all on this journey towards making this world a better place, a more peaceful place. I was hoping to share some thoughts, and maybe let's say 3 hopes relating to court annexed mediation, the international commercial mediation, and the Singapore Convention on Mediation. Right, just three aspects. For court annexed mediation, I think, Peter, you referred to this, you alluded to this. I think all over the world, the courts are feeling the burden. It's not been possible to deal with so many disputes, and there are backlog of cases all over the world. I think in one jurisdiction that I went through recently, and it's very common, sometimes it takes 8 years, 10 years, even longer. And the quality of justice suffers with delay. Mediation helps ease the load. We know that. And Ibaran, I've seen firsthand. I've been to your legal clinics, your courts, your mediation rooms, and you're doing a fantastic job. Many of you. I mean, this is really touches the soul. But in reality, we know the load is still there. It's very heavy. Singapore had a backlog of cases 30 years ago. I just want to share a little bit, and I think many of you know, mediation was actually introduced through the courts in the 1990s to help eradicate the backlog. Lawyers were resistant at first. We were all very cautious. But I think now I can say safely after 30 years, the courts have encouraged mediation, practice directions have come in. It is now the primary form of dispute resolution in our courts. Almost every case is mediated. And in the state courts, the lower courts, more than 90% of the cases are resolved successfully and don't see the light of a trial. The system in Singapore is also hybrid because we also have a private mediation center. We now have 2 main centers, the Singapore Mediation Center and the International Mediation Center. So the private sector, lawyers, engineers, doctors, we also mediate cases. And for the larger cases, we charge a fee. And for me, that is a way in which the whole of society is involved. And India, you have to find your own way, and you're probably best poised to decide what is best for India. But for us, that has worked. And I can say hand on heart now, our lawyers have embraced mediation as part of the dispute resolution process. So it's taken us time, but there is now a change in mindset. The courts have just introduced, this is the very latest, a new initiative. So in the past, it was court cases which were mediated. Today, our Chief Justice has introduced a new rule, it's called Order 5, which says that before commencing an action, a party has a duty to make an offer of amicable resolution. And that could be just negotiating, or that could be mediation. So you can see the shift now to even before a party files court proceedings. And that is the mindset change we're now moving towards in Singapore. Telling people, and somebody said mediate first, right, before litigating. This is what we're trying to tell people to do. Even before you file, think about other ways. In a sense, this is not alien to us. I mean, for Hindus, you had your panchayat system, right? That's how we used to resolve matters. Go to your village elders, go to the community, work it out amongst ourselves. For the Chinese, we have our clans. In Singapore, penghulus, the village heads who would help mediate cases. So maybe it's one full circle. So on this note, I would. This is my first hope for India. As I said, you best know your system. You best know your situation. I have seen the progress in India myself. Many years ago, it was not that known. Not many people are aware, but today, people are aware. I'm told many cases are being mediated. And Honorable Justice Vishwanathan, I'm sure you and your colleagues will find a way, all right? This is my hope. Perhaps to make mediation the primary form of dispute resolution in the courts. Society will follow, okay? So that's my first hope. The second thing about international commercial mediation. In Singapore, we have Singapore Mediation Center, which focuses on domestic cases, and then the international cases are dealt with by the Singapore International Mediation Center, which I chair. I've also seen the growth in international cases. We now realize that actually it's not just domestic cases, but there are a lot of cross-border disputes. Business people who want to do business don't want to be caught in long, drawn-out arbitrations or litigation. SIMC, we have seen this. This year, we had our largest case, a US $4 billion case. Okay, it's going on right now. It's going to take a few tranches, but working well. This year, we had 2 claims against governments, nothing to do with Singapore. Claims against governments, parties flew into Singapore to mediate their cases. Both were successful. In one case, the Attorney General of that country flew in. And you know the impact once the other party saw the Attorney General. He was so happy. Got somebody who could decide, who had authority to decide. And that case was settled too. So there is a need in the international scene, okay? Today, I'm sitting here in Seoul in a hotel room. And that's why the lighting is not so good. I just spent the last 2 days mediating a case. It was a dispute between an European company and a Korean company. US $56 million involved. Tough going. Parties flew in, but we resolved it yesterday. At the end of the mediation, the parties took a photograph together. Can you imagine that? Can never imagine this being done in court, right? So for me, this is really the beauty and the value of mediation. People from different cultures can even do this successfully. In April, SIMC was invited to run a training course in international mediation in Hyderabad. Justice L.N. Rao invited us. He was your chief guest in August last year. Justice Hima Kohli came as well. I'm told we had a very good group. Training went well. People were very encouraged. So this is my second hope, all right? That people like you, Indian mediators who are experienced, will also get trained in international mediation. In India, you know, you are the largest, you are the most populous country in the world today, right? Or soon to be 1.4 billion people. India should take its rightful place in the international arena. Okay, take the lead. You have great minds, big companies, and I would really love the chance to work with Indian mediators in international mediation. All right, the third area, the Singapore Convention on Mediation. I was part of the deliberations at the UN in UNCITRAL between 2014 and 2018, which led to the adoption of the Singapore Convention on Mediation. When I was at the UN, we kept on asking the Indian delegates, are you going to sign? And they were not sure. But 1 week before the signing ceremony, India decided to sign. I think it was Prime Minister Modi who held a cabinet meeting. I've seen the note. India signed, and we were so happy because US, India, China signed, 3 largest countries in the world, more than half of the world's population. Okay. Unfortunately, COVID happened after that. It sort of put a dampener to the convention, but things are picking up now. Countries have come alive. We have 56 signatories today, 11 ratifications. I'm so glad that Peter and Santan have been going around spreading the good news, the message that more countries should come on board. Because think about our international arbitration. Where would it be without the New York Convention? It would not have taken off. Okay, it's the same for us in the mediation community. For many years, we wanted the equivalent. We now have it. It's for us to make it happen. Now, this is the punchline. India needs to ratify the convention. Signing it is good, but you need to ratify because you are the largest populous country in the world. For me, it would be a signal to the world that mediation is important in India if you ratify it. Now, when I was in Hyderabad, there was one speaker who alluded to the fact that your ratification process, there have been some issues. I'm not sure, okay? Justice Vishwanathan, maybe you will know better. Maybe you can address this. But I'm really hoping that the ratification process will come about quicker, sooner than later. It's not advantageous for India from my perspective. If India ratifies, you really give a very strong signal to the world. And I think if that happens, it will be very good for the mediation community. And for you guys, because I think we have so many aspiring mediators who will look to the country, to the courts, to the government to take the lead on this. So if anyone has influence over this process, I hope you will use that, and we hope to see India ratifying soon. So that is my third hope. Okay, my last message is to the young aspiring mediators. You are going to take a 10-day course. I'm very impressed. I've seen the program. It's a really good program. You've got good trainers. Train well, but I think the mark of a good mediator at the end of the day is patience. It took me more than 20 years to build a mediation practice. Today, I'm a full-time mediator. I mediate like two cases a week, and it keeps me alive, keeps my mind and my heart. Okay. And we all know mediation is a form of access to justice, right? It's good for ordinary people. It's good for businesses. It's good for peace and harmony. And even for the lawyers, I say this, it's good for our souls. It keeps our hopes alive. It keeps our ideals alive. So thank you very much for this opportunity to address you. And young mediators or young aspiring mediators, I wish you all the best. Thank you very much.
Thank you, Mr. Lim, for sharing your frank thoughts and ideas. I am now delighted to introduce the chief guest of the evening, Honorable Mr. Justice K.V. Vishwanathan, Judge of the Honorable Supreme Court of India. Honorable Mr. Justice Vishwanathan is not only an eminent, but also a well-loved and respected former member of our Supreme Court Bar Association, who was elevated to the Supreme Court recently on the 19th of May this year. Honorable Mr. Justice Vishwanathan has the rare distinction of being amongst the few lawyers to be elevated straight from the bar to the bench of the Supreme Court. As stated in the collegium order appointing him a judge, he was elevated because of his sound understanding of law, his his profound knowledge, his integrity, and wide experience. Many of us who have worked with you, sir, and have had the privilege of knowing you, have seen that Mr. Justice Vishwanathan has this admirable ability to be totally in the moment, whether he's speaking with you, reading a brief, or playing with his cat. Mr. Vishwanathan has had a meteoric rise. He completed his integrated 5-year law course from the Coimbatore Law College, soon after which he moved to the Supreme Court in 1988. He joined the chambers of Mr. C.S. Vaidyanathan, designated senior advocate, and then the eminent senior counsel, Mr. K.K. Venugopal, former Attorney General of India. Mr. Vishwanathan started his own practice in 1995 and was designated a senior advocate at the early age of 43 years. He was appointed as an additional Solicitor General in 2013 and has been an eminent member of the editorial board of the Indian Law Journal, the Supreme Court Cases. He has been appointed as a member of the NALSA, which is the National Authority of Legal Services in India, a premier body set up to provide free legal aid to the needy, and it is also the overarching body for mediation in India. He has argued innumerable landmark cases in the Supreme Court of India, including as an amicus, for many years prior to his elevation as a judge. To mention just a few, it's impossible to mention them all. In the year 2002, in the case of Salim Bar Association, he was appointed as a junior amicus, where the Supreme Court appreciated his assistance while upholding the validity of Section 89 of the Code of Civil Procedure, which provided for reference to mediation by the courts. In the case of Lalita Kumari versus the government of Uttar Pradesh, decided in 2014, where the court for the first time laid down that the registration of an FIR is mandatory in the case of cognizable offences, Mr. Vishwanathan assisted the court as an additional Solicitor General of India. In the case of Swiss Ribbon of 2019, Honorable Justice Rohington Nariman greatly appreciated the assistance provided by Mr. Vishwanathan, senior advocate, in interpreting the Insolvency and Bankruptcy Code. In the 2018 case of BCCI versus Kochi Cricket Private Limited, Mr. Vishwanathan was commended for the assistance provided to the court in interpreting the meaning of arbitral proceedings. He is known to have supported and taken up pro bono matters for teachers and the personnel of armed forces. So, coming back to mediation, our endeavor as mediators is to try and lighten the burden of the judiciary while helping restore relationships through mutually agreed settlements. We are grateful that many honorable judges are thinking mediation first when a matter is placed before them. Honorable Justice Mr. K.V. Vishwanathan, can I please request you to address the gathering and to formally declare open the 4th Summer School on Mediation. Thank you.
Thank you, Shireen, for that generous introduction. Mr. Peter Menard, President of the Commonwealth Lawyers Association, thank you very much for that enlightening address that quoted the Mahatma, the great Sri Nelson Mandela, Mary Angelou, and not the least J.K. Rowling, and covering a wide landscape in your speech. Mr. George Lim, President of the Singapore International Mediation Center, your light in the hotel room may not be sufficient as you feel, but you have thrown sufficient light, sir, in the address that you have given us today. Mr. Rakesh Khanna, former President of the Supreme Court Bar Association, and somebody who has been instrumental in promoting Nivaran. Shirun Kajuria, distinguished member of the bar and an avid mediator. Mr. Ray, co-host, an avid mediator. And Santana Krishnan, Santan to friends, convener of Nivaran. Thank you very much for inviting me to be the chief guest for this evening's event and to have bestowed me the honor to declare the 4th summer school open. At the outset, I would also like to congratulate the Commonwealth Lawyers Association and the Singapore International Mediation Center for having teamed up with Nivaran in sponsoring this very significant event. I was aware of Santana Krishnan's interest in cricket, but probably the DRS method that has been introduced in cricket as an alternate dispute resolution has prompted his interest also into mediation, and that CLA is now lending a helping hand to create an awareness on the importance of mediation in India and across the globe is itself very significant. I say this for the reason that while you see the metamorphosis of the mediation evolution in India, all the necessary statutes, the infrastructure, the impetus from the Supreme Court, the institution to which I belong, has always been there. The judgment in Krishnamurthy precisely appealed for the Mediation Act, and today we have a mediation bill which is on the anvil. The judgment in Salem Bar, which you mentioned, Shireen, did highlight the importance of the alternate dispute resolution process, of which mediation is an important component. The judgment in AFCONS and in Patel Automation have only shown that the institution is prepared to put its hand up to, give impetus to mediation. The whole host of statutes in India, even prior to this mediation bill, starting with the Order 32A of the Code of Civil Procedure, which in the 1976 amendment introduced reconciliation for matrimonial and family law proceedings. You have the Industrial Disputes Act, which had a provision, which still has a provision. You have the Small Industries Act, which has a provision. You have the Arbitration and Conciliation Act, which devotes a whole chapter to conciliation. But the problem really has been, and that is what I want to focus on, is in the awareness of the importance of mediation as an alternate dispute resolution in the legal community. And I think that is where your summer school, the 4th, I find, apart from the series of lectures and seminars and interviews and chats that you have hosted, will come as a big boost for this method of alternate dispute resolution. My experience at the bar and in the brief spell that I've had on the bench, I find that not that there is a resistance to mediation, but there is somehow an impression, at least in some quarter, that by this concept of mediation, somehow it is believed that there is a coming down of the merit of their position and their case. And I think this is where you will have to really address and create what I would think, and probably it is one of your topics beginning tomorrow, a culture of mediation in the country and in the legal fraternity. I say this for the reason that in matrimonial disputes, when we have been suggesting mediation, some quarters have responded by saying that Honorable Court, the couple cannot live together. So why are you trying to explore that? Whereas, as the word Nivaran itself indicates, it is redressal. It is not, a decision in the sense of a nirnay. It is Nivaran. It is reconciliation. It is a happy end to a dispute that is being contemplated. In the process of discussion, after the pros and cons of a dispute are analyzed, a mediator with the experience would lay bare before the parties the possible roadmap the litigation would take, would do a cost-benefit analysis, a back-of-the-envelope analysis, and that would highlight what would be in the interest of parties in the immediate future so that they can move on and work out their rights. That awareness is what I think is of primordial importance. And apart from the technical aspects of mediation, which you will focus, I am sure the seminar and the workshop would focus on ingraining in the participants the concept. Most of them would be proficient mediators themselves, but as you enlarge the community of mediators, the concept that this is really, as Mr. George Lim mentioned, a method where there is a win-win situation. In fact, Mr. Khanna also mentioned, and it was so happy to hear that in a dispute as large as one involving $56 million as stakes, parties were happy to have photographed themselves together in a dispute in Seoul, which you mentioned. I think this is the importance of mediation, so that the relationship continues. Even the business relationship could continue thereafter instead of ending in acrimony, as a dispute would invariably result. So the problem number one that perhaps we may have to address on a very large basis is the concept of awareness and embedding in the mediating community and in the litigating community, the legal fraternity, a culture for mediation. Because today we have the statistics as far as India is concerned, and I could get it from the parliamentary committee report, which commented on the mediation bill, that as of July 2022, and the National Litigation Grid must give you the figures as of today, but this is something which I checked up immediately, that in the district and subordinate courts in India, you have 4.05 crore cases pending. In the high courts, you have about 56 lakhs, which is about 5.5 million cases. And in the Supreme Court, as of that day, it was 69,000. So there cannot be two opinions on the fact that mediation is the immediate desideratum, so that disputes which can be resolved amicably with parties sitting across the table with a seasoned mediator who could be the sounding board for them, because parties in dispute will be difficult for them to meet. I'm talking of post-litigation mediation. It will be an enormous help if the mediation as an alternative dispute resolution can relieve the courts of the huge pendency which they are facing as of today. Mr. Lin, since I represent the judiciary, I have very little say in what India as a country would take a stand on its ratification. I will not even be able to comment. It will depend on the do's and don'ts and the pros and cons of it that you debate in this workshop, and the awareness that is created for the policymakers to decide. But there is one aspect of the mediation bill that I want to make bold to comment, and which Mr. Khanna mentioned, not so much in the context of the bill, but about government disputes now, by a government order. being persuaded to be taken to mediation. I think that is a very, very welcome step, because it is an accepted fact, and that's problem number 2 that I would want to highlight today, is government is by its very nature the largest litigant, because the government is also dragged into litigation. Parties litigate with government, and government also sometimes to protect its rights and resources are forced to litigate. But the problem that really will arise, and I think Mr. George Lim flagged that issue in a case where the Attorney General landed up and the parties were convinced that the highest decision-making authority was there. That's the real problem. Who would take the decision to send a dispute to mediation and to accept the proposal that the mediator would ultimately work out? Because we have bureaucrats of exceptional ability. Let there be no two opinions about it. And they have the ultimate interest of the country in mind. There are several bureaucrats, but they will have a problem as to assuming a responsibility to take a decision, even if in the best interest, some vested interest could, create an issue out of it, so that the decision-making which you mentioned with government could be a serious issue, and that has to be addressed, and some out-of-the-box idea needs to be suggested, because while mediation as a method of resolution should apply across the board, but the genuine problems which are faced also needs to be addressed. I have been, even from my bar days, thinking about it, and I say this as a legal scholar, not so much as somebody holding office, that if decision-making was an issue, generally, to compromise the matter or even to recommend mediation or to accept the proposal, if, there could be statutory committees which could be headed by the retired district judge at the district level, retired high court judges at the high court level, who could resolve and sanction that this is a dispute which has to be mediated. And even if a proposal is forwarded and the department may have genuine difficulty in taking a decision to accept it, even if they genuinely feel that this was the roadmap to the litigation, that could also be taken to the committee. And on the endorsement of the committee, it could be, accepted, so that the responsibility is also endorsed. There is a backing for a decision bona fide taken. Because I think that problem will also address government and public sector disputes from, being kept off the anvil of mediation. And it could go a long way in weeding off cases which pend, so that the mediator would give them a roadmap, would do a cost-benefit analysis. So if we can address these two problems, and these are suggestions as to how it will be carried forward. It's for all of you experts to decide, considering the pendency, considering the fact that the Supreme Court has felt that it is an important method, most important method perhaps, for alternative dispute resolution, so that these problems are addressed and a solution presented. Thirdly, as you go along with these workshops and create a large community of mediators, it will also help in lawyers adapting to this concept of mediation and becoming not just mediators, but litigation counselors. You don't have to have pre-litigation counseling bodies. I don't know whether that is caught up on a large scale, because today you have marriage counselors, you have health counselors, but if a litigant wants to litigate and if he needs a prognosis as to how his case would unfold and what are his chances of, meeting with a positive result, and to what extent is his case likely to succeed, there are no independent counselors on a large scale who would advise him, so that he, before embarking on a litigation, has what is called a report before him. If lawyers themselves are trained in this, and they become not just lawyers, but litigation counselors, and that is also required because a lot of frivolous litigation could be nipped in the bud even before it is filed. And the legal community also would, in the long run, realize that as a lawyer who is also a litigation counselor and who's prepared to give a fair, considerate, objective advice would be more sought after, even in business. So I thought, since you are about to embark on an important seminar, I've seen the topics, you have some experts on this field who are going to address you. But if these concerns also could be addressed, we could get the benefit of the legal structure that is already in position, the support from the judicial institution, which is available, which is reflected in the judgments, and the mental mindset is also brought in line, so that we achieve the object of mediation as an alternate dispute resolution, to relieve the courts of the pendency and to give an impetus to rule of law, because then disputes which cannot be resolved for whatever reason will ultimately get quickly and expeditiously disposed of in courts. So it is a win-win situation, as Mr. Khanna mentioned, and why I declare this 4th summer school open. I commend the participants who have registered for it. I commend the speakers who have volunteered to take the sessions and address the participants. And I wish the workshop all success. I wish Nivaran, the Commonwealth Lawyers Association, the Singapore International Mediation Center, and all the participants here in this event all success. And I wish you good luck. Thank you very much.
Honorable Justice Vishwanathan, thank you so much for throwing open the summer school. We are extremely grateful to you for your insights, and you have rightly highlighted that the culture of mediation has to be developed. And this is probably one of the first steps towards it, the summer school. Thank you once again. As we come to the end of the inaugural session, Mr. S.S. Ray, fondly known as Shesh in Nivaran, a well-respected advocate and a mediator at the Supreme Court of India, will give the vote of thanks. Shesh, please.
Thank you, Shireen. Thank you, all the speakers. I wish to mention each of them specifically. Mr. Rakesh Khanna, former President, SCBA. Thank you very much for culling out the fact that this is our 4th year in the 4th summer school. We started in 2020 and we refused to get stumped with the intervening COVID, and we continued with this program. And thank you very much for bringing forth what our Chief Justice had mentioned: mediate, don't litigate, and also to bring forth the Government of India notification, which encourages mediation. Thank you, sir. Dr. Peter Maynard, President, Commonwealth Lawyers Association, thank you for joining us from around the globe at such an early hour and telling us about mediation as a transformative means of dispute resolution. Thank you very much for mentioning Mahatma Gandhi, the father of our nation. He was one of our best mediators and somebody we really look up to when we think of mediation. And of course, goes without saying, mentioning Nelson Mandela was very, very important. It's iconic because two of the very, very iconic people in the world who stood for nonviolence and for mediation. Thank you, sir, for that. And that mediation is becoming a functional in a multiple domain system is very important that you highlighted this. It is really breaking down geographies on this. And last but not the least, you really connected with the younger people over here by mentioning J.K. Rowling. Thank you very much, sir. Mr. George Lim, sir, we look up to you as not only as chairperson of SIMC, but as an iconic mediator and a teacher for many of us. And we have attended a lot of your seminars and webinars otherwise to enrich ourselves. And you have rightly and correctly pointed out the overburdened system where sometimes the litigation takes even more than 10 years. And that just as you mentioned that lawyers were resistant in Singapore, I must point out that in India as well, we had a similar experience. When the first judgments and the first introduction of mediation came in 2005, lawyers in India were not at all willing to accept it. It's been a very, very slow transformation over here. But as we can see that mediation is taking up a lot of alternate dispute resolution, or if I may say, a lot of people say this ADR should actually be named as appropriate dispute resolution. So therefore, it is taking up a lot of space over here. You're right to say the panchayat system has been one of our foremost bedrocks of mediation. In fact, the panchayats have been given a constitutional status under after the 74th Amendment. And successful mediation, which you have just finished in Korea, I am sure when you say that this is good for the soul and good for the business, you actually are practicing what you are telling us. Thank you very much for that. Honorable Mr. Justice Vishwanathan, thank you very much for joining us. Thank you very much for blessing this and summer school, encouraging us and motivating us towards mediation. You have absolutely and correctly identified the problem, that is the awareness of the institution of mediation as ADR. But simultaneously, it is only your sagacious wisdom that gives us the solution also, that embedding the culture of mediation is very, very important. Yes, we do need to have that. And when you say that decision-making can have the committees at the district level, I think that is a path-breaking thinking. That when we have the stamp of authority saying and certifying that, look here, that these are matters where we certify that maybe, you know, they should go for mediation, I think it will go a very, very long way. And it's a step forward in the sense where the government at many times where the decision-making, and you've correctly pointed that out, that decision-making is the most important thing. In fact, at the start of any mediation, the first thing that we actually ask the parties is that, are you authorized to decide? Otherwise, there is no point, because we are going to sit down here to arrive at a solution. So empowerment is very important. To that extent, your thought on this process is absolutely on the spot. And the large community of mediators will encourage the lawyers to have litigation counselors. I think this is also very, very important. Just like somebody goes and, as you pointed out, marriage counselors, you take that, so to say, the litmus test, just to see where do you really stand. Because many a times we find in mediation, and often my experience tells me mediation doesn't get successful until unless a certain amount of litigation fatigue has set in. But that concept is changing. Mediation is even being pursued now as a pre-litigation objective and voluntarily, not just by way of statute. Thank you very much, sir. Thank you very much for all the encouragement and for the very informative thought process. I welcome all the participants in the summer school. We have 10 days of intensive training ahead, and we have a beautiful faculty over here, extremely learned. We will have Mr. Brian Spears, who was a former president of Commonwealth Lawyers Association. He will speak on the historical perspective and the development of the legal structure culture. Then, of course, we will have Mr. John Bassey. He is the president of the Jamaica Bar Association. He will speak on overview of conflict and conflict management, resolution, and transformation. That is the second day. The third day, of course, we will have the Deputy Attorney General and Deputy Minister for Justice from Ghana. And we look forward to her contribution in the introduction to mediation, definition and process of mediation, difference in mediation protocol, etc. On the fourth day, we will have Professor Andrew Goodman. He is a barrister in practicing in London, and he will be speaking on communication skills needed for mediator, verbal and non-verbal communication. On day 6, we will have a senior advocate, Mrs. Sushila Sarathi from Karnataka. She is a very experienced mediator, and she was my teacher as well when I was undergoing the mandatory 40-hour training. And thereafter, we will have Mrs. Uma Ramanathan, and she will be addressing you on ethics, ethical issues, confidentiality, neutrality, which are core subjects on mediation. And I may add, she was my teacher as well. Then we will have, of course, Justice Sudhir Jain of our Delhi High Court. He has been encouraging mediation for a very, very long time and has been very active on this. And he will be speaking of course, on online mediation and advantages and disadvantages of mediation. And then, of course, we will have from Johannesburg, Mr. Duncan Turner, who will be speaking on mediation advocacy. And finally, we will have a talk on the Singapore Convention and International Settlement, the scope of application and future of mediation. And for that, we will have Ms. Yang from Hong Kong and Mr. Robert Gerard. Lastly, we will have Justice Vashisht Kokaram, who we have had from Trinidad, who we have had the opportunity of interacting on this very platform, and we've had his blessings earlier also. And he will be speaking on UN and SDG and mediation. I look forward to seeing all the participants for the next 10 days of intensive coaching. Good luck, and I hope that we will all go back home more enlightened, just as lawyers continue to learn at every stage. Therefore, we remain students forever. Thank you very much. Thank you once again to all the speakers. Thank you, Justice Vishwanathan.
Thank you so much, Shesh, for the vote of thanks. I would also like to thank Rahul and his team for taking care of all the technical issues. Can I conclude the inaugural session by reminding all the participants that the first session starts tomorrow at 5 p.m. It's for about 75 minutes. The guest faculty, as Shesh just mentioned, is Mr. Brian Spears, an eminent exponent of mediation and former president of the CLA. And our host will be one of the founders of Nivaran, the designated senior advocate, Mr. Jitendra Sharma. We look forward to all of you joining us, and thank you for being with us today.
Thank you so much.